Hey everybody, so welcome to this week's The Tuesday Tip with Katie Crown. I am actually live. I'm sorry I'm late, but I was making sure that I connected with the person that prompted this live. So today we are going to talk about wrongful termination and what are some of the steps that you can take if you have not gotten to the place where you have an attorney, or even if you can afford an attorney. There are things that you can do if you are working in a hostile work environment. So the prompting of today's tips came from Ready or Not 96. So I did tag her or mention her in the title of today's live, but I was heartbroken by the sheer pain that she was enduring with this very complicated situation. So I just wanted to share some information that a lot of folks may not know. I realized that yesterday while looking through the comment section. So one of the first things that you can do if you feel like you have been wrongfully terminated and you don't know the first step to take is contacting your internal HR department. Now, with that being said, typically the HR department is always going to be your first line of defense. You may not get much of a response from them if, in fact, you try to connect with them after your termination. But anytime something happens at work, you want to make sure that you are involving your human resources department. So next, say for instance in the off event, whatever is happening does result in you getting fired. What do you do first? So I saw a lot of comments that said get an attorney, but there are things that you can do before then, and that is the EEOC. So the EEOC is a federally run organization that essentially covers, helps, supports employment and employment rights. And usually employment attorneys at some point will engage with the EEOC. But depending on why you were terminated, you want to know the classes of protection by the EEOC or protection by employment laws. So one of the most important distinctions is when people think about, oh, I was wrongfully terminated, they don't really realize how many areas and classes that we're protected under. So off the rip, the main classes are race, color, religion, sex, gender, age, disability, and also genetics. And some of these are absolutely obvious, but for this particular case and this particular tip, we're going to be talking mostly about sexual harassment. What does that cover? What class does that fall under? And it actually falls under the class of sex. When you think of sex, you would think, are you fired because you're a male or a woman in a male-dominated industry, or a male and a woman, whatever the case may be. But in this particular case, the termination was a result of on-the-job sexual harassment. And so this young lady was not sure which direction to go, which class she would be covered under. Oh, sorry for the background noise. This is real life. Which class she would be covered under or where she could start. So I advise the first thing to do is to contact the EEOC. When you reach out to the EEOC, you can, on your own, for free and without an attorney, begin the process of filing a charge against an employer that has wrongfully terminated you. One of the most important things to remember is always going to be documentation. Anytime you're opening up an inquiry, anytime you're going to go through the process of actually filing for the charge, you have to be really detailed, and in chronological order is typically the best. But what you would do is you would go to the EEOC website, and all of the categories that I mentioned or classes that are covered that I mentioned, you would select which one is applicable to you. So to keep things easy, we'll go with sex and sexual harassment. So in this particular case, you would want to document the the date of the harassment, when it occurred, any details. And when I say any, I mean any details that led to your termination. Some of the things that you think may not be important are very much important. What day did you contact your supervisor? What day did you send an email to the HR department? At what point did someone circle back to you and either try to support you or remedy you? And this happens in more cases than people think, and it happens to both men and women. So that's one thing. In your details, be very descriptive. Sometimes some of the things that may have happened are very personal, but in order for the EEOC to effectively and make a decision with fidelity, you do have to share the bitter details and the details that may be uncomfortable. The next thing to remember is timing. Every state, even though the EEOC is a federally run organization or is a federally run entity by the government, each of our states have their own rules that apply. So typically there is a 180-day statute of limitations. So from the time in which the first occurrence happened, hi Diva, hi Saints, hi there, thanks Elia for joining. From the day that the occurrence happened is when you want to start keeping track of your documentation. In addition to that, making sure that you don't pass the statute of limitations is key. And we've talked about organizing your evidence. So if you have emails that you send to HR, make sure you print them out or have taken a picture of them or a screenshot and are able to upload them as evidence with your claim. In addition to anything that you journaled as evidence to your claim, and then any witnesses, other co-workers that you have told about what happened. The good thing to remember is you can do things anonymously. Your claim, you don't want to claim anonymously. However, any witnesses that are fearful that something could happen to them by them supporting you, they can be named anonymously within the claim. And then most importantly is be prepared for the EEOC to reach out to you in case they want additional information. Hi Beverly. In case they want additional information about an interview, because one of two things can happen. An inquiry is one step in the EEOC process, and then the actual filing of a charge is a supplementary step. In this particular case, based on what Ready or Not 96 described had happened to her, I would advise that she was ready for the charging portion. So because she is one of the protected classes, that's one thing, but her harassment had been documented and it created a hostile work environment. That is one of the main components that a lot of times people don't understand the direction that you need to go when you're either filing a claim against your employer or you've experienced some sort of retaliation on the job. Hi John, thank you guys for joining. Is to remember that there is documentation, but also that you cannot lose sight of why you are filing the claim. And I think I just lost my train of thought because I have so many friends here. Gosh, you guys are so supportive. All right, so formal charge. If this young person has decided that this is the path that she's going to take, if she has the evidence, the witnesses, and the documentation that we discussed, then she's ready to file the charge. Once that process is complete, the EEOC will actually make a determination as to whether or not it is a case in which they will try to mitigate or mediate and or take on or not. And in most cases, especially if you have gotten to the place where you know your evidence is rock solid, they will likely take your case on. This is all without an attorney. Again, those of you who know me know that the reason that I do this is not that I don't absolutely love and adore the profession of law. I do. However, it can be cost prohibitive, and a lot of times there are things that happen in our life where whether or not we have money should not be the end result of whether or not we receive justice if we have been wronged in some way. So my comment that I added to her was that she was protected under multiple classes. And one of the other comments back to me was, what exactly does, like, what does that entail? What does that mean? So not only is she a woman in a male-dominated work environment, one would think, okay, well, maybe that's the reason, or maybe I'll go with that as my filing. But that's actually not the reason. Being a woman in a male-dominant environment or being a man in a woman-dominated environment doesn't necessarily mean that the EEOC immediately is going to look at your claim or look at your charge and say, oh, this is it. This is the way to go. No, we all work together. But in her case, her supervisor expressed that he had some feelings for her. It made her uncomfortable, and she was then moved to a different location. And once she reported to Human Resources the details of her, situation, they moved her to a different location. But the supervisor got wind that she had moved to a different location, and he was being investigated internally, as I understand it, for this harassment. Well, that's when the retaliation began. This is when the work environment becomes doubly hostile. Not only do you have a supervisor that is acting in a way that's inappropriate, you also now have an environment where you're kind of on eggshells. So the next step in her situation was that the harassment covered everything. She couldn't ask questions. She was being berated. There were certain tools that were needed, and she was getting written up for all of these small things. So it was causing a great deal of anxiety for her, even just to go to work. This is not how we are supposed to go to work every day. You are not to go to work as a man, as a woman, as anybody to be harassed or feel like you are being picked on or singled out, and only for the reason of you just don't want to be harassed, or you don't want to be sexually harassed, in this case at work. There are protections for you. So you should familiarize yourself with what those are and be very familiar with utilizing the free tools such as the EEOC to protect yourself in the event that this should happen to you, and allow a government agency to determine whether or not you have a viable charge. Again, this is done on your own. If you have a computer, if you have a telephone, you can engage with the EEOC and an email address on your own. The portal is there for employee protections. If there are any employment lawyers that have joined, because I think I tagged Legal TikTok, please feel free to chime in. But this I know to be true from my own experience. So what happens in this case where her supervisor decides, you know what, I like you, okay, I think you're pretty, I think you smell good, whatever the case may be, and says, if you would engage me or go out with me, I'll make sure that you get promoted. That is not only unethical, but it's legally called quid pro quo. And what quid pro quo means is this for that. In an employment situation, in an environment, you should never have those type of exchanges. We go to work to get paid for our hard work, and we expect to be recognized by way of promotion or raise or whatever the case may be for our level of work, not because we engage some creep that decides that they have a crush on you and then want to exchange you dating them or engaging them for your work performance. So quid pro quo is an actual legal term. Be sure to include that with the EEOC, because that will help them recognize that you're not just, some person making up claims. You actually understand some legal terminology and know how to help yourself. This is considered unwelcome advances. So not only is the work environment hostile for being sexually harassed, then you've got unwelcome advances, which falls under the same category. But the killer and how she ended up getting terminated and why I think the EEOC will definitely take this claim or take this on as a charge. She was late for work. Now, her work performance had been stellar all the way through this process. Great deal of anxiety. It's a high stress job. But one particular morning, she was late for work. So the angry, retaliatory supervisor fires her. And not only does she get fired, she is barred from working at any of the other, hi there, any of the other locations that are run by this company. So this poor young lady was at her wits' end. And I just wanted to be sure that she knew, not only from the comments that I shared with her on her live or on her post, but going into further detail. And so I made it available for her to join today. So if you are out there or in the audience, my friend, Ready or Not 96, please raise your hand and let me know if we have not covered enough of details to be able to help you. But in the end, discrimination of any form, unequal treatment, it is not only uncomfortable, it is against the law. So every Tuesday, what I try to do is my absolute best as a consultant. This is what I do for a living, even though my office space is not very professional today, but this is real life. But I try to give my followers and those that are interested in ways to navigate complex issues, whether you're at the place where you're deciding to get an attorney or whether you're trying to figure out whether or not an attorney will help you, you can arm yourself. There are certain things that you can do as a self-represented person that in some cases, like in this case, you don't necessarily need an employment attorney out the gate. You start with the available free agency, which is the EEOC. So on that note, as long as we've covered everything that we can in a short time regarding wrongful termination, I'm just going to give a quick recap. Make sure you follow and like and comment and share. Every Tuesday, you will find me here either live or with a pre-recording. But today, I'm definitely live. But our EEOC wrongful termination 101. Make sure you utilize the EEOC. Make sure you have all of the evidence and witnesses for filing a charge or filing an inquiry. That would include any
CA's
communication
doing it.
with your human resources department. It would also
Yep.
include any times that you
You're
have
messed
talked
up
to
me.
your supervisor. It would include any time that you have written down or someone witnessed the ill treatment. So that is going to be what is comprised in your external reports or evaluations that you're going to organize in chronological order from the first occurrence of the harassment until you were terminated as evidence to support your charge with the EEOC. You want to make sure that your state has statute of limitations. All of our states do. Make sure that you're filing your claim within your state's statute of limitations for harassment or cases or charges handled through the EEOC. For us in Indiana, and for many states, there is a pretty standard 180 days from the day of the occurrence or the firing or the first occurrence of harassment. And then lastly, once you have filed your charge or your inquiry from the EEOC's website, make sure that you are available and ready in case they decide to have a more formal investigation of your claims or charges. There you can go into detail, make sure you're referencing the documents that you've already uploaded, and if you want to share anything else, by all means, be sure to do that as well. But my goal is just to be a resource. I want everyone that feels that they are not empowered in areas of law and business, and even as an entrepreneur, to know that there is a resource. And I come and visit every week for Katie Crown's The Tuesday Tip. So without further ado, I will see you all next week. I hope, Ready or Not 96, you joined today. I'm dying to find out what is the end result of what happened with you, and please reach out if you need help, because there's no employer that can ban you from every location within an organization. That's absolutely preposterous, and it is clear, whether you have the confidence or not, or to believe that you brought any of this ill treatment onto yourself, you absolutely did not. Quid pro quo is a law that was broken in your case. You were experiencing a hostile work environment in addition to being sexually harassed, and you are protected under multiple classes within the federal guidelines that the EEOC will support. So without further ado, I hope to see you all again next week. Hey, Terry. Oh my goodness, I'm so glad all of you all joined today. Any topics you want to discuss, you can always send me a DM. If you have issues dealing with custody or probate, that's a new one. Identity theft, I've had some exciting news in that department, and how you can partner with the Federal Trade Commission without an attorney on your own if you've had your identity stolen or compromised. And I think that's pretty much it. Criminal too. Veterans Affairs. I'm just here as a resource. So I will see you next week. Anytime there is a topic that I want to front load you all with, I try to post in advance. But thank you all for joining today, and I look forward to seeing you next week. Bye-bye. This is great. We're live. My daughter is cracking up in the back seat because I forgot how to get off live. Cheese.